Hello and welcome to this webinar entitled Commercial Agency Overview, and that's presented by me, Keith Markham. My background is I am a company commercial lawyer, worked in a variety of places and guises over the years, dealing with lots of scenarios to do with commercial agency, hence why I'm here to talk to you about this today. As always, let's begin by having a look at our agenda. So the first thing we'll look at is the issue of applicability. We will see that we have issues in terms of the common law, but that's not our main focus today. Instead, we're going to look at the particular rights and duties and obligations set out in something called the Commercial Agents Council Directive Regulations 1993, and we will go through that in detail. That will be our main focus today. Now, the key thing to note is that for those rules to apply, then ultimately a commercial agent has to satisfy a certain definition. And we'll see that that has three key elements. First of all, that they must be a self-employed intermediary, they must be negotiating in respect of sale of goods, and in particular, they must act on behalf of another. And what we will see is that over the years, there's been a huge amount of case law arguing about the precise nature of that definition, whether it should be interpreted broadly, i.e. to favour as many agents as possible, or narrowly to reduce the scope in terms of its application to agents. And we'll see that typically the courts have taken a broader approach to interpretation. Now you might say, what does it really matter? Well, the reason it really matters is that there's quite a lot in here about duties on the part of the agent and the principal, particularly duties on the principal to do certain things. But over and above that, there's the issue that these regulations provide far greater rights for commercial agents than are typically found in the common law. That's why agents are very keen to get the protection of these regulations, and principals are very keen to avoid the application of these regulations. Now, alongside that, there are then two specific things that we will be talking about in some detail. Minimum notice periods. So we will see that within the first year, it's a month, second year, 2 months, third year, 3 months. There are exceptions to that, which we'll come to. But then the key thing, the biggest area of exposure, and this is why principals particularly want to try and avoid the scope of these regulations, is because of this idea. In some cases, we will see that if the agency comes to an end, the agent is entitled to a payment on termination, and we will see in what circumstances that is going to be made and also how that will be calculated in practice.